Welcome back to our real estate education channel. Today we're breaking down one of the most tested and most misunderstood topics in property ownership, methods of taking and holding title in North Carolina. If you understand this clearly, you will eliminate a major source of confusion on the exam questions. So, let's simplify it. We'll talk about the big picture. When we talk about title, we're answering one question. How is the ownership held? Did you know under North Carolina law, ownership can be in severalty, as tenants in common, as joint tenants, as tenancy by the entireties. Everything flows from these four. Let's take a look at ownership and severalty. Severalty simply means one. It could be one legal or one natural person owns the property. That could be an individual, it could be an LLC, it could be a corporation, it could be a city. And when that person dies, the property passes by will or through intestate succession. There is no co-owner. Tenancy in common. Did you know this is the default method of ownership in North Carolina? You have multiple owners, each own a percentage, but each owns the entire property in an undivided interest. Some of the key characteristics of tenants in common: number one, ownership percentages can be unequal. Number two, there is no right of survivorship. And number three, at death, the interest passes to the heirs. And this is where students get confused. Let's do an example. If Fred owns 50% and he dies, his share does not automatically go to the co-owners, the other co-owners. It goes to Fred's heirs. This is the exam trap. Let's take a look at joint tenancy. Joint tenancy requires the four unities. That's the unity of possession, the unity of interest, the unity of time, and the unity of title. We call this a PIT, P-I-T-T. All of the four unities must be present. And some of the key features of joint tenancy would be the most important, the right of survivorship. But in North Carolina, that feature doesn't come automatically. It has to be requested. When one owner dies, their interests automatically pass to the surviving joint tenants. But here's the nuance. If one unity is broken, the joint tenancy can convert to tenancy in common. That distinction matters. Let's take a look at tenancy by the entireties. Now, this is a special form of ownership for married couples. Now, legally married couples. It includes the right of survivorship, which means that a will doesn't take precedence. Protection from individual creditors is treated as one legal entity and only available to legally married spouses. If the marriage ends, it converts, typically to tenancy in common. So some very key insights that you want here. Here's the test level thinking. If ownership passes back to the grantor, that's going to be a reversionary interest. If ownership passes to someone else, that's a remainder interest. Understanding how title is held, it helps you to determine what happens at death. That's the connection. When you see a question about ownership, slow down and ask, who owns it? How are they holding title? What happens at death? Clarity removes confusion. In our next video, we'll break down the difference between tenancy in common and joint tenancy using real exam style scenarios. If this was helpful, subscribe for more structured North Carolina real estate exam prep. I am Your favorite educator, Alicia D. Berry, the D. Berry difference.